Tēnā koutou katoa, no America ho no te tematanga, no ototahi toku kainga e nai nei, e roia toku tunga mahi o Perryfield Lawyers, ko Stephen mo toku ingoa, no reira nā mihi kia koutou katoa. Hey everyone, it's really wonderful to welcome you to our webinar today. We're looking at charitable purposes, particularly focusing on trusts, and we're really excited that so many of you have joined and are interested in this topic as well. Our aim is to provide helpful, useful information, whether you're involved in a charity, whether you advise charities. There's a wide range of you joining, we know. My name is Stephen Moe, and I'm a partner at Perryfield Lawyers. We are a law firm which has a real focus on impact and purpose. We have a national focus with 5 different offices and about 100 people. And we have teams that focus on property, disputes, corporate commercial. So basically covering most areas of law. And I'm really lucky to be joined by 2 amazing colleagues and friends. And we're going to be having, I was saying before we hit record, it's just a discussion. The 3 of us are going to have a discussion. So we've got Anna Rosebeer here, who's in my team, the Impact team, and Paul Cowie from the Disputes team. So thank you both for joining.
Thanks. You're welcome. Thanks for having me.
So I thought we might start with a karakia just to open up the meeting. So take a deep breath and have a listen to these words. Whakataka te hao ki te uru, whakataka te hao ki te tonga. Kia mā kina kina ki uta, kia mā taratara ki tai. E hi ake ana te atakura, he tio, he huka, he hauhu, ti he Māori ora. And that karakia is, get ready for the westerly, be prepared for the southerly. It will be icy cold inland and icy cold on the shore. May the dawn rise red-tipped on ice, on snow, on frost, a glorious day. So before we get into the main content, just a couple of things. We would love to hear from you. You could tell I was looking at the laptop there. I'm in this session as well, and I'm going to be able to see the chat. So we know you know how to use the chat because you gave us the weather forecast where you are. And we would love to hear from you. What are your questions? What are your comments? If we're talking and you're like, oh, there's another resource, feel free to drop it. And we want to make this as interactive as possible, bearing in mind that it is online. But the beauty of online is, I think there's 112 people that signed up. And we know many of you are watching this afterwards as well. The other thing to let you know is that we have a lot of resources. And so this is one session that we're doing today, but we're about to release this paper called Collaborate, How Charities Can Work Together. We just released the Community Housing Legal Guide. This is called How to Chair a Meeting. This one's on impact investing. You get the idea. There's a lot of resources. And the other thing that we released recently is Changing Paradigms, a book, 24 essays. How do we do things differently when it comes to charity and business? So Bridget's online and she's going to be dropping links to some of these things in the chat. So welcome everyone to this session. And for those of you just joined, I'm here with Paul and Anna. We are really excited to talk a bit about charitable purpose. And Anna, I'm going to turn to you first. When it comes to charitable purpose, why is this important? Why are we having this webinar? What role does charitable purpose play for an organization?
So a charitable purpose for a charity is really like the beating heart of the organization. It's its North Star, it's its why, it's its core, Stephen. But it's more than just like marketing kind of values talk that you might hear if you're working in a business. Because your charitable purposes are something that you have to advance in perpetuity. So that means that it's something that you, if you're a trustee on a board, have to advance as your guiding North Star forever. And that is what sets it apart from like the purposes of a business, I think.
And this is something that's a bit, like you say, it's different to business because charities are given a special position in society, really.
Correct.
And they get both the standing. Currently, there's about 29,300 registered charities, and they get standing as being part of that group, but they also get tax position. So there's an incentive to join and to be clear on your charitable purpose.
And it's a real privilege to have that
Yeah.
charitable status. And then there's also the layer that under the law, there's a definition for a charitable purpose, Stephen. So we have kind of the 4 pillars of what a charitable purpose is in our Charities Act, and that's taken out of case law, and Paul will talk more about that later. And those 4 pillars are you advancing religion? Are you advancing education? Are you relieving poverty? Or is your purpose beneficial to the community? And some people think that 4th one might be like a catch-all for anything that's beneficial to the community, but it really is very driven by case law, which Paul will speak to later as well. It's quite a difficult bucket to come into in some circumstances.
And it's interesting. So I did a law degree, obviously, because I'm a lawyer, but my other degree was a history degree. So this is actually, if we were to go back, it's 1601 that it was first introduced. These sort of, they didn't express it that way, but
no,
that was the first. It was called the Statute of Elizabeth. So just for the history buffs out there, this actually has origins going back 425 years. Pretty amazing, isn't it?
Yeah, Queen Elizabeth I was the one to bring it in.
Yeah.
And history actually is a really good thing to note about this, because in one sense, particularly as trustees, but the idea of a charity is that effectively it's someone else's baby.
Right.
And we've been, if we're trustees or if we're administering that, we've in fact been entrusted with their baby.
Yeah.
And so the charitable purpose requires us to look back and say, well, what is it that they were trying to do here? Not what do I feel like doing, but what did they want their baby to do?
Yeah. And I think it's a really important point. They're called charitable trusts, right? Like trust is inherent in what you're doing. I trust you with this money to advance these purposes. Yeah. Sometimes I think we forget that origins of what are we talking about?
Yeah, that's right.
Yeah.
Because ultimately it's often their generosity and their gift, as the language of the court says, that has established the trust. And although sometimes people come along later and make decent sized donations to charity, the founding gift, if you like, that the settlor makes is really the one that sets that North Star that we're talking about, that defines the purpose. And so there is that historical necessity to look back and say, well, what were they trying to do?
Yeah, that's really good. So for everybody, some of you have joined, I know, after we hit start. We're going to be using the chat function, so feel free to be dropping questions or comments as we're going. And we would love to hear more from you.
So if I could, Stephen, one of the things I think we've been talking about purpose as being something that informs what the intention and what the desire of the founder was. But I think legally, of course, it's the ambit of what you're allowed to do. So it's not just a nice to have.
Correct.
The charitable purpose is to a very large degree the rails on which that charity has to run. And I think it's not for that reason, it's very important that you do have a good understanding of what that charity was intended to do, that you've been entrusted with, because that's all you can do.
I like that, because the other thing is that sometimes people get so focused on doing good in the world that they forget what's the good that we were set up to do. And there can be a temptation. This segues really nicely to the next sort of topic. And maybe, Paul, do you want to continue talking on this? What is it that can happen to charities? What is it that can go wrong when it comes to purposes?
Yeah. Well, another way, not to mix too many metaphors, but if you look at the driver's license example, where if you've been given a license to go and do something, that's great. And let's say it's a motorbike license. If that's what you're entitled to do, then that's what you're entitled to drive. Now, it may very well be that winter comes along and it would be much nicer to be in a car. It may even be desirable and you might even have passengers. But if your license is only to ride a motorbike, then you're not allowed, you're not you're not permitted by the terms of your trust to jump into a motorbike and start riding that, because you've only got license to use what you have. And so it is with a trust that at some point in the dim and distant past, someone might have had a good idea and decided to provide for a specific charitable purpose and intention that was important to them at the time. Over time, as you say, society changes, geography changes. We have gold rushes that come and go. We have technology that wasn't thought of 20 years ago that suddenly is in the middle of our lives now. And for these sorts of reasons, what seems to be like the right thing to do or a good thing to do from 60 years ago might suddenly be rendered irrelevant now. When you think about someone, for instance, horses as a mode of transport in cities are now very infrequent, whereas in the past that was front and center of transport. So there is that tendency for us as trustees to look at what we should be doing and what we could be doing. Whereas the way that the law looks at it is to say, you have a charitable purpose, and it's that purpose that was established right back then, which is what you must be doing and what you must be, what you've been entrusted to fulfill.
Okay. And that's showing as the main video now. Okay. So we're gonna switch back to this this video. So what you're saying, I love the picture of a license that you are able to operate a motorcycle, or you're able to operate a heavy vehicle, and actually that's what you have the mandate to do. So when it comes to charities, if you got the license, to use that terminology, to advance education of preschoolers, and then 30 years later, your board is sitting around thinking, well, actually, the environment is really important. Climate change is devastating. It's going to affect everybody. We need to do something in that area. What you're really saying is that you have a license for education. You don't have a license for climate change. Is that?
That's right. And it's particularly important to realize that this particular trust in your example, the hat you're wearing as a trustee of that trust is to get busy promoting educational aims. That's not to say that you might not want to be involved in another trust doing something else, and you certainly can, but you just can't commandeer the assets that were established for the purposes of education in your example to do some other laudable aim, because that's not what they were given for.
Okay. And I have to say, I've seen this personally over the years, where charities come and what they want to do is amazing and really good, but it's so different to what they were set up to do. The example I give, the people I work with get tired of me saying this, but we were set up to run a preschool, and then some funding came up so that we could work with high school students. And then some more funding came up for suicide prevention of graduates. And then some more funding came up, and you can tell that over time it's diverged off, and you're actually no longer operating within the umbrella of safety that's provided by your purposes. So Anna, maybe we can turn to you, just thinking about your governing rules. So this would be your trust deed, and in our situation, what sort of things should people be looking out for if they were coming to review their rules?
Well, Stephen, there's an obligation that's come in quite recently into the Charities Act, which requires the officers of a charity to review their governance procedures every 3 years. And the first cycle of that review is finishing up in around October this year. And this requires the trustees to consider, are their rules, one, fit for purpose? So is your trust deed fit for purpose? Do those rules assist you to achieve your charitable purposes? And thirdly, do the rules assist you to comply with the Charity Act's requirements? So it's really very centred. Really very centred, this obligation to review your governance procedures. It's very centred on your charitable purposes and whether basically are you advancing those purposes which your trust was set up to achieve.
Yeah, so, and this is, I think it came in October 2023.
Yeah.
And the 3-year period is nearly here.
It is.
If anybody's interested, we actually held a webinar about this topic, like the overarching how to review your governance procedures. Anne-Marie and I did that maybe a couple of weeks ago. And Anna and I will be in the Auckland office doing a free webinar. Actually, it's not a webinar, it's an in-person on the 20th of August about how to review your governance procedures. So you're welcome to join that. We'll put a link in the chat to that. Okay, so we're reviewing our governing rules and we come to the purposes, and everyone on the committee or in the board is saying, these purposes, I'm not sure if they're really matching what we do today. And let's start with something simple, like just terminology use. So the terminology that was used in the 1950s when the trust was first set up, it had certain meanings, certain ways of thinking about words. And today we maybe don't view them the same. Maybe I'll start with you, Paul. If a board has that, so we're starting at the end where maybe it is possible to change things. What would be your advice or your thoughts about what would be acceptable?
So when you're looking at purposes, the courts have always been jealous to hold trustees to account that they're following those purposes. So, and for the reasons that you give, because there's an asset that now isn't subject to tax and all those reasons. So that's the court approaches it. Now, obviously, over the hundreds of years that the common law has approached these problems, that there is an ambulatory nature of words, if I can put it like that, where words that start off with one meaning, over time, over the decades, they can change. So you are obliged as a trustee to try and understand what was meant in your trust deed. That's the first thing that you look at, the language that's there. And then, in addition to that, you can look at other things that the donor may have found important. So you might, for instance, know that they were particularly fond of animals, so that will colour the way that you can interpret the language. It's not necessary that you need to be constantly making changes. If you're able to understand what the words are, then blend that meaning and follow that. Now, I think where you're coming to, Stephen, is that sometimes the language actually is quite restrictive. I know what it means, but we are struggling to do this. And there's 3 categories of things that the court look at. Sometimes the trustee will allow you to change the purposes. And a trustee might say, as long as it's charitable, then you guys can do whatever you want. So in those circumstances, with good advice, trustees can actually do that. But sometimes you might not have that luxury. So then you've got to go and generally go to the courts. And the original test was, if it's impossible to carry out that purpose, then the court will make a change. If it's impracticable to carry out the purpose, then the court will make a change. So, for instance, if you'd left money to establish a school in the parish of wherever it is, and that was a gold rush town, which over 50 years became a ghost town, so there were literally no people there, then it would be impracticable to be establishing a school for a town. I know what the town is, but there's no one living here. They all moved out 60 years ago. So that would be impractical. So that was the beginning. And then in 1928, I think the court added, or the Parliament added in a further slippage, if you like, reason for amending a purpose, which is if it's inexpedient.
Okay.
So those are the 3 reasons that a court, if you don't have any power to change your trust's purposes, you can go to the court and say, one of those 3 reasons applies here. So could you please assist and make by a court order a change to my statutory purposes.
Yeah. And one of the things I should have explained, hopefully it was clear at the beginning, but Paul is the type of lawyer who goes to court and stands in front of the judge and gives the arguments and explains what's going on. So you've actually had practical experience of this sort of scenario, whereas for Anna and I, we're more behind the scenes reviewing documents rather than the ones who go to court.
Yeah.
Yeah. Okay, that's really helpful. So do you want to run through the three tests that you've just outlined so that everybody gets it clear?
So just again, impossible, impracticable, or inexpedient.
Yep.
And impossible is, for instance, where there's been a change to law, or there has been some other local government change, for instance, and the purpose for which you were set up. So, for instance, to provide support to a district health board, that district health board no longer exists as such. It's been disestablished, and there's been a new body. So it's actually not possible.
Yeah.
No.
So the impracticable would be the example that I gave maybe of a school in a particular parish where there are no people living anymore.
Ghost town.
So a ghost town, I know what it is, and I could, if I want to, have the maintenance done and the school there functioning, but of course impracticable to do.
Yeah.
And the third one is inexpedient. And the interesting thing about that is that it is an evaluation that the court is doing. And it isn't looking at how to carry out that original purpose. It's precisely saying it's not useful for us to carry out that original purpose. It needs to change. So, and I think the inexpedience issue is to look at whether it's that value judgment and saying, well, is this going to be a useful thing? And that's where you can, especially with changes in language use and changes of the way society acts over time, we understand different things, for instance, about education. We understand different things about, for instance, medical diagnostics, medical treatments. So there's a whole lot of those things where the ground has changed.
Yeah.
So that the purpose, it's more expedient to actually carry out to benefit people in this way than it was in the way that the founder originally stated in the language used in the trust deed.
Yeah,
Okay.
that's really helpful.
Yeah.
And the other thing that I've seen practical examples of this, where you get a religious charity and the terminology and the way that the purposes are described has actually shifted. So in the 1950s or 60s, it was described one way, still doing the same thing today, basically, but we don't use the same terminology today. So that's something that could fit in some of this as well. And the other bit that I've seen with the Christchurch earthquakes, which happened here, obviously some things no longer exist, a little bit like your ghost town scenario. So this trust was set up to be for the upkeep of the stained glass windows in this particular church. And of course that doesn't exist now, so those are the scenarios. And if you didn't have this, of course, there'd be assets or money tied up in things which were just not able to be done.
That's right.
Yeah.
I mean, you can put too many words around it, but the words that the court have used for inexpedient is unsuitable, inadvisable, or inapt. So again, it's a change because it's not impossible.
Yeah.
And it's not impracticable.
Yeah.
But it's inadvisable. And so an example might be, for instance, that apparently in World War II, doctors were regularly prescribing cigarettes to soldiers in order to help them manage stress. Now, if there isn't that I'm aware of, but if there was a charity that was established to help provide cigarettes to stressed soldiers, you could do that. You certainly could. But is that advisable?
Yeah.
May well be that what we understand now about medical science would make that an inexpedient kind of behavior. The best way to help a shell-shocked soldier would not be to arguably to be providing them with cigarettes.
Yeah.
So
it's a great example.
Really good.
Yeah. I've seen it as well, where using our way of approaching things, you would look at a trust and say, that's an outdated way of looking
Mm.
at a particular societal issue, or, you know, like this trust was only set up to provide swimming lessons for 10-year-old boys or
Yep.
something like that. You know, it's just so very specific and probably not what we would do today. So,
Mm.
yeah.
That's right. And that's a very good example, because there are examples where charitable gifts have been made, in one case to provide sporting facilities for boys of a particular age.
Yeah.
And they were allowed on the inexpediency ground to amend that so that it was just simply people, males and females,
Yeah.
between those ages. So again, you can understand what was the language is perfectly clear. It's not impossible, but in hindsight, it's inexpedient.
Yeah.
And sometimes you have the views that were common amongst benefactors last century. You might find using language that is clunky, or that is difficult to understand. So, for instance, there was another test where the beneficiaries of a scholarship could obtain something as long as they were in good health.
Right.
Now, the court held that again, we can kind of understand what the word good health means, but the court said it's very difficult nowadays to actually understand where's the cutoff between good health, and why would it benefit people to actually, potential scholarship recipients, to say, yes, I'm in good health. We know more about our health now because of the diagnostic ability. And so someone might actually have a disease, but it might be well managed. Are they in good health or not? So the court actually removed that. It didn't provide any assistance. It was an expedient for that hurdle to need to be met by recipients of that particular scholarship.
Yeah. Well, these are great examples. And I'm going to turn to you, just thinking about trustees themselves. But just before I do that, I see the chat has got lots of comments and questions. So we are going to come back to the chat, and we're going to do our best to go through as many of these questions as we can. I can guarantee there's going to be some comments with very specific fact scenarios or something. We're really happy to engage and have a dialogue, but just be aware it might have to be after this. So feel free to reach out to us if some of this is provoking your own, like, what would this mean in my context? Because that's really the intent of this session. But Anna, I'm just thinking, if we did have a trust deed in front of us, what are some of the other causes that would be relevant? So we've talked a lot about purposes and what might be possible to be changed. What other causes might be relevant? I'm particularly thinking of some little hidden causes that sometimes aren't there, like the variations and amendments. You want to talk a little bit about that?
In terms of what you can get put into a trustee?
I'm talking about, we've got a trust deed here from 1952. What sort of other causes do we need to be checking? Like, for example, amendment causes, and whether we can even vary.
So if we're stepping back into our trust document, and we're thinking, how can I check this is fit for purpose? Kind of the first clause you might go to is, do I have an ability and a power to amend to make this fit for purpose? And that clause, you need to really carefully read that to check what you can change, because some clauses only allow you to change administrative things. Sometimes there is a restriction in terms of what you can change that might impact on tax, for example. So that's kind of your first port of call once you start this review of your trust document. What does that amendment clause say if it does allow you to change a trust deed? And assuming it does, then you might start looking at things like updated terminology. So, for example, your trustee might talk about appointing a chairman. So we often recommend that that is turned into modern language, like a chairperson.
Yeah. And the other thing is sometimes you're looking, and it might not be called amendment clause, it might be called a variation clause, or it may not have a a name at all, but the content is that you can alter what your trustee says. But sometimes that clause will say something like, you can alter the trustee, but you can't alter this clause, which is the purposes
That's correct.
clause.
That's what you have
So
to.
that you might be thinking like, oh, great, I found the amendment clause, and then realize when you read it, it specifically, and the reason is that the founders were thinking, well, we don't want this to be amended, and therefore we are, you know, ring fencing what can be changed.
Yeah, we often find those types of clauses, don't we, Stephen?
Yeah. Now, the other thing, just to throw in, and I'm going to turn to you, Paul, in a second, just about the Act and what it says, our favorite sections 32 and 33. But the other thing is, if you do have a trustee which is so outdated, like we've dealt with sometimes they're the 1860s, 1870s, and there's just no provision for variation, and it's completely outdated. At the end of the day, sometimes what you need to do is set up a brand new charitable trust and start to come up with a purpose within a different legal entity rather than trying to salvage the old one. Obviously, there's other questions that then come about, such as, can you transfer the assets out of the old one into the new one? Is there a power to do that? Is it matching the purposes? We don't have time to go into all of that, but I'm just alerting you to the fact that sometimes the easiest way is actually to set up a brand new charity and then move assets into it rather than trying to adjust the existing one. Because there is time. And actually, Paul, do you mind talking a little bit about court processes and the time involved? This is an area that, to be honest, is another webinar again, which is access to justice and the time things take. But yeah, just talk us through, if somebody did want to modify their trustee, what's the sort of process that they would need to follow?
Yeah, the distinction you drew earlier, Stephen, about the purposes, or what's sometimes called the objects, and on the one hand, and then on the other hand, you've got the administrative details of the trust, which are sometimes called the powers. So, and the courts have long held that distinction, and there's a different approach for both of them. And the reasons, in one sense, aren't particularly relevant because that is what it is. So, if you're wanting to look at the purposes and say, look, these purposes have become impossible, impracticable, or inexpedient, then and you've got no power in your deed, then your only option is to go to the court and get a High Court judge to look at what's called a scheme and say, yes, I agree that whichever head of that is that applies. So I've got power to do that, and then the court will assess whether the court should make the amendments that you've asked for. And there are various service provisions that you need to get around, and you also need to notify the Attorney General. So for their view. So, and the court then generally will look and they will try to make the smallest modifications that they can, because bearing in mind they're stepping away from the whole purpose that this gift was given, and they're now broadening it or sometimes even changing it. So the court will then look, and they'll go through a process where they're assessing, clearly it needs to be charitable. It needs to be have been charitable at the beginning, and it needs to still be charitable. The court will then look at trying to get the purpose that's close to what was originally intended, but taking into account the changed circumstances. So in the ghost town analogy, that's a circumstance that the donor couldn't foresee. So now that we know that this area has become a ghost town, how is it that we can stick as close as possible to what was intended at that point? And then finally, the court will look at what sort of beneficiaries was the donor who established this trust. What were they wanting to do? Who were they wanting to benefit? And how can we make sure that that group gets benefited? So those are the questions that you really need to focus carefully on.
And it's interesting, there's almost circumstantial evidence then as well, like the intention of the donor, what was going through their mind at the time that they did this, and is there other evidence? So it's presenting I guess a scenario or a explanation about what you want changed and why,
That's
and
right.
how it matches what the donor intended.
Yes, you're exactly right, because those last 2 points that I mentioned, looking at what it was that they were trying to do and seeing how the change in circumstances has affected that, but also looking at who it was that they were wanting to benefit. But both of those require, as well as you can, to understand what the settlor was trying to do.
Yeah. And you mentioned another term, just so that people know, the Attorney General. I kind of view the Attorney General as the conscience of charities. That's sort of the role that they play, isn't it? Like you're going to them first, you're getting their perspective, their input. And presumably if the Attorney General said, I don't think this is a good idea, then the court is going to take that into consideration. Is that right?
That's right. That they occupy a constitutional place to keep an eye on what's going on. And again, if you look at it, the government is requiring that the quid pro quo for no taxes and no duties is to ensure that the public of New Zealand are benefiting. So if you were to take the assets of a trust and say, I want to benefit my own children, that would clearly be personal pecuniary benefit, which has nothing to do with the original. A, it's not charitable, and B, it's unlikely that it would have to do with that original purpose. So you're right. The Attorney General is that part of the government that keeps trustees honest and that makes sure that they are honest to the original intention of the trust as it can be amended through the statutes that the Parliament has passed.
And I'm going to ask you in a second just any practical tips you've got for clients or people listening to think about when they're going through this process based on your experiences. But Paul, timing, cost, court, what sort of time frame are we talking about? Because to go to court, it's not like, oh, well, we'll see you next Monday. This is a longer process, isn't it?
It is a long process, and it's where you want to measure twice and cut once. You do need to get a really good understanding of what it is that you're doing. So what we were just talking about, finding out what the original settlor was intending. All of that background digging, so that you can put together a well-articulated basis for the court to show where we started, where we've gone, and where we want to go, and why, court, we need your help now to make this amendment under Section 32. So that time takes as long as it takes, really. In terms of once someone comes to us with all of those ducks in a row, so that we can work on that, it generally takes a bit of time to bounce back and forth. You need to make an application. You need to establish the scheme, which has to comply with the Act. You then need to liaise with the Attorney General. If it's a smaller trust, the Attorney General will probably apply less resources to it. But some larger charities, you can understand that will excite a bit more attention from the Attorney General. So they will then put more time, the Solicitor General's office, Crown Law will spend more time looking at that. And sometimes there can be back and forward, and sometimes we will go and actually meet with them and discuss with them how that goes. So then and only then are you ready to file those documents in the court. And that process is a matter of months. It depends how long and how busy your court is at any particular time. But you certainly shouldn't, from the time that you file it, you won't be getting a hearing date within sort of the first couple of months. It's more likely to be sort of 3, 4, sometimes even longer. And the other thing I mentioned, the advertising requirements. From time to time, you do see people who read those advertisements that they're picked up. They will also have an opportunity to appear before the court. They can do that in writing, or they can do that in person. And that can also prolong the
Mm.
process.
Yeah, so there could be
Mm.
interested parties
Yeah.
that get joined in and have something to say. And the other thing to remember is we're not just talking, I mean, for some charities, we're talking about $100,000 or $10,000. It's significant, but not millions and millions. But some of these charities, we are talking about 20 million, 50
That's right.
million, 100 million. So
Mm.
you can imagine that it does take time. The courts are going to want to get it right.
Mm.
They're going to be asking questions.
Yeah.
I think for Anna and I, our pace of work is such that a client comes to us on a Monday,
Mhm.
we try to have turned the document around by the Tuesday. You know, it's like very, very fast. So sometimes we just have to tell clients,
Mm.
hold your horses. It's going to take time to prepare the applications, to get the dates, to actually file, to go to court. And yeah, people need to keep that in mind, I think. Yeah. I'm going to come back to you in a second, Paul, because I do want to get into the nitty gritty of 32, 33, which is the core causes. But Anna, you've been through, and as a firm, we do this quite a lot. As you can probably tell, we've helped multiple clients going to court and being able to get their purposes changed, or if they don't need to, helping them through the process of doing it themselves. But Anna, any practical thoughts from you in terms of, I know you're doing one right now. What are some things that you wish people knew about
in terms
this?
of preparing a scheme?
Yeah, just preparing a scheme, or maybe I always use the word taking people on the journey, you know, like it has to be more than just one person. Any practical things that you can think of?
Yeah, I think that's a really important thing, Stephen, to take all the trustees on the journey.
Yep.
So, for example, sometimes we'll go in and we'll do like a face-to-face governance procedures review workshop. So we might walk the trustees through, like, what are your duties under the Trustees Act?
Yep.
What are your obligations in your trust deed? And we'll talk through with them, like, how does your trust operate? How do we need to change these rules so that it reflects how it operates?
Yep.
And what were the settlers' initial intentions? Because often it's not in the trust document.
Yeah.
So we need that golden information from the trustees. And I think that really helps if you have the budget to get someone in like us to do that kind of workshop. And then we might turn that workshop into a governance review procedures report, which goes to the trustees, and then they can see in writing what's been agreed at that workshop. And I think that's another way to bring more of the trustees on the journey, Stephen, because that's, from reading that report and talking about it in a meeting, that's how everyone gets to be on the same page as to what are we trying to do by going to this High Court, because it's not cheap, is it, to do a High Court scheme?
No.
Compared to just, changing your trustee by a deed of variation. So it's a big decision for the trustees.
Yeah, I really like that. I think you've emphasized some really important things. And often the trustees themselves may not have known the donors, because it was set up 75 years ago.
So new trustees.
So the new trustees may need to reach out to the former trustees or go back into the archives. We've had people have to go to official records, that are not held by the entity anymore, because it's literally decades ago, and trying to work out, well, what was going on? What this got moved here, and why was that done? So it's really important point that you're raising.
And it's not just pointless either. You can see from the judge's point of view, the judge, and as you say, Stephen, some of these trusts that have lasted for 100 years have become quite large, especially if they've been given decent size chunks of a city, for instance. They can become very valuable. So a court's being asked to make a decision that involves changing something that was given for a particular purpose and using it for something else. So if you put yourself in the judge's shoes, they want to be sure that they're not being led, having the wool pulled over their eyes, if you like. So that there needs to be a level of comfort for a judge before you can ask them to be changing purposes.
Yeah, yeah, it makes total sense. Paul, I'm curious, I've kind of hinted at this, but Section 32, Section 33 of the Charitable Trust Act, 1957, it's going back itself quite a ways.
It is.
Do you want to, we won't spend long on this, but just briefly, what's the difference between the two and how might it be used by some of the people listening?
Yeah. So Section 32 deals, and what we've been talking about today is purposes, objects, what the settlor was wanting to do with these assets. So Section 32 is the provision that allows a court to change those as long as those three things are met: possible, impracticable, or inexpedient. On the other hand, Section 33 deals with the way that trustees can manage things. It's the administrative thing that you mentioned earlier.
Yeah.
So that's their powers. Now, of course, 100 years ago, the way banking happened was different. The way lots of things happened were different. So if you had a trustee that was particularly keen on assets being held in gold, that might have made sense 100 years ago.
Yeah.
Whereas now, of course, there's a whole raft of different issues that trustees need to be taking into account. So those are the administrative sort of things, the powers, and the court has a different standard for amendments to them. Again, sometimes your trustee will actually give you the right to do that, but sometimes it doesn't. Sometimes the settlor has said, no, you can go on and do exactly as I tell you to do. So if you've got one of those trustees, you can go down to the court, and the test that you need to meet for that is that you can, a judge can amend those powers or those administrative opportunities for you, provided it facilitates the object of the trust. It just has to facilitate your purposes. And the facilitation test is it just has to make it easier.
Right.
Okay.
I think the word is that
Yeah.
that it needs to make it easier to promote or help forward is the way the courts have held it. So it's a much lower standard. You just have to say this would be better. So to go back to the driver's license, on a horrible rainy southerly, when it's tipping with rain, you can say, look, it would be better if I could take a car rather than take a motorbike.
Totally.
So where those restrictions relate to administrative powers, then it's the facilitation test, which is a much lower. Again, you need to be clear that that you can't just run in there and just say, I don't particularly like that. I want to put all the trust assets into Bitcoin.
Yeah.
A court might say, oh,
yeah.
So the court will still exercise control, but it's a much lower standard of necessity, if you like, that you need to show in order to get a judge to expand the powers of a trustee.
Yeah, that's great. Well, if people listening or watching, if you're interested, feel free to drop a line to us. We're really happy to look at questions that you might have. Paul, one thing we haven't talked about is some of the people listening are saying, well, this is interesting, but I have an act of parliament, which set me up. Let's just, we don't have time to go into all the complexities here, but particularly some religious groups I know we've worked with where they would say, well, actually, we have this thing from the 1920s or 1940s. We are a setup. Any additional things they need to be thinking about?
Well, some acts of parliament actually allow deeds to be amended by a liturgical court.
Right.
So sometimes you don't have to use the High Court of New Zealand. Sometimes there are powers within the Act itself. And if they don't apply, then where there's an act like that, then you will have to follow changes. And in some circumstances, it may very well be that you need to amend an act.
Yeah.
But again, Stephen, I think you mentioned earlier that sometimes if you're wanting to do something that isn't within the objects of an original trustee, it may even be better to set up a new one and try and use fresh assets, not the existing assets, but sometimes depending on what it is that's being done.
Yeah.
But that's a piece of string question, that one.
It is.
Yeah. But it's interesting because what I'm seeing more and more, and this hasn't come out yet publicly, but I'm about to put out a book called Changing Paradigms of of business.
Mhm.
It's called the impact company paradigm. And in that, I'm looking at, well, what's our conceptions about charity and
Mhm.
business? And so for some groups, this little paper here might interest. It's going to be released very soon. It's on impact investing. So a charity, maybe setting up another charity isn't the best way. Maybe they could do it through a business or an income learning
Mhm.
approach. And I'd like to think that all of you would not be so wedded to the entity type that you are that you forget you're here to advance purposes. And you need to look at what is the purpose and then work out, well, what would be the best vehicle, whether it's a motorcycle, a car, a four-wheel drive. That's what you need to be doing, is how can we advance our purpose? So we're coming towards the end of the session. As you will have appreciated, there's a complexity here. And one of the favorite answers that a lawyer will give you if you ask them a question is, well, it depends. But as you can appreciate it does depend on the circumstance. It depends, what does our trustees say? What's permitted? Is this an admin change? Is it a fundamental change? What were the circumstances of the setup? What does the attorney general think? There's many flowchart, yes, no, yes, no. I'm curious, in the chat, somebody, I'm going to try to answer as many as we can, but in the chat, someone said, what sort of cost is involved in going to court? Can we give a ballpark picture, or is it just, it will depend on the circumstances?
You're very unlikely to get change back from sort of the mid-20s. So 25-ish thousand plus GST and disbursements is roughly where a lot of straightforward, simple amendment applications might land.
Yeah.
What frequently happens, however, is that in order to get a better understanding of the settlor's original intention, there's some complexity. And having done that, it may very well be that the Attorney General may or may not raise issues. And sometimes there's just complexity in articulating for a court why it is that a purpose has become inexpedient.
Yeah.
So sometimes it can be very, very much more expensive than that. But yeah, that's kind of what you should budget. I think the easiest thing really is to obtain an opinion first as to what can be done, because like you said, Stephen, sometimes establishing a new entity might actually be a better and more cost-effective way for a trust, for a charity to move forward, rather than repurposing something into something that's significantly different.
No, I like that. Anna, we kind of touched on this, but there's a question here: how often should we review our charitable purposes? Not to necessarily change them, but to ensure that the language, emphasis, and tone is up to date. Any thoughts on that one? We've got this 3-year type of thing, don't we?
Yeah, I think it does swing back to the minimum is your 3 to do that 3-yearly check to, are your purposes fit for purpose? So that's the test in the Charities Act. And then, for a matter of good governance, depending on how big your charity is, you may need to make a decision that you need to make that assessment more regularly. Do you think, Stephen?
Yeah, I totally agree. I always view that these legal documents they're not tablets of stone. They're organic and living, and over time you do need to review them. And also, if they were tablets of stone and they're stored in a bottom cupboard that no one ever looks at, they're not actually doing what they're meant to do. Because as you were saying, charitable purpose, it's the heart of the organization. If you can't be clear on your why, then how are your volunteers, your employees, your customers, suppliers, the whole ecosystem going to know what you're about? So you need to be really reviewing them quite often. There's just a couple comments here, like I've observed that there is scope creep when contracts are on offer. I think that's particularly in the current funding environment somebody's added. So that's definitely true. And I'm just saying here, how much can you rely on evolution staying within the original purposes, but shaping today's circumstance without needing to go to court? I think we've probably covered that enough, but
it's a cracking good question. And all I'll say about it briefly is that There have been cases where trustees have gone and done something with an asset,
Yeah.
and the court has wrapped them over the knuckles and said no. So it can be what's called ultra vires. In other words, it's beyond the powers
Yes.
of your trust deed to do what you've done.
Yeah.
So, for instance, the transfer of a racetrack from one entity to another was seen to be beyond the power of the owner. So the court brought that back. So I suppose a modest change, that's linguistic, that's fine. But when you start dealing with assets, you can and should be aware that there's liability that attaches to trustees.
Yes.
So deal with those assets very carefully. And if there is ambiguity about whether you're allowed to do this or that with it, then absolutely seek advice before you do that.
Yeah.
Yeah.
And I guess the other thing is that if you did make a decision and you went ahead on this other course and you modified your purposes and you added in additional purposes and you totally change it, then there's an argument that there's been a resettlement of the trust. And that might trigger things as well. That IRD might get interested, and there could be tax implications as well. Yeah. So I guess hopefully we can't cover everything in our hour, but hopefully we're giving you enough hints about what are some of the signposts, some of the things to be concerned about and aware of. So we're really happy to engage with you and answer questions that you might have. We haven't gotten to every question, but I think we've answered most of the themes which are coming through there. So that's really good. I want to say thank you to Paul and to Anna for joining me on this webinar. We've really enjoyed having you here. I'm sorry for the technical things at the start, but hey, we just adapt, we go with the flow, and we make do. And I think it's turned out really well. I'm really happy that we're able to share this. We will be putting up a recording. If you found it helpful, then we would really appreciate if you shared it with other members of your board or with others who you know are in charities and maybe they're looking at some of this. I wanted to emphasize a couple of things that we mentioned at the start. The first one is this Changing Paradigms book. So this is a free resource, 24 essays from leading thinkers about the future of charity and business. As a law firm, what we want to do is, even if people don't come and use us as our clients, we want to stimulate discussion and get people thinking about the role of charity and business in society. So some amazing people there who've contributed, and you might enjoy that. They're very short, 500 words each. This one here is on charities donation caps and the missing analysis. I wrote that with Dr. Julia Chevalier-Watts at Waikato Uni. And this is looking at the recent budget changes. So you might be aware of the 100K cap. So that's not a one-off donation, that's an aggregate over a year. It affects about 350 people, but guess what? They give about $100 million a year. So it's quite significant. And this paper was published by the New Zealand Law Journal, and it's a free download on our website. Normally, if it's in an academic paper, you can't get it, but they said this is an important issue. So we'll let you have it for free to download. And this one we just put out about 10 days ago. I was in Sydney speaking at a charity law conference. So it's comparing Sydney, Auckland, and just thinking about charity policy. What is it that we can learn from different jurisdictions? So it goes through a table format. This was published with the Council for International Development. So Todd there co-wrote it with me. They are basically the peak body for the largest overseas focused charities. So names that would be household names. So that is another free resource. And the final one, in the invite to this, I put a link to this paper called Collaborate, How Charities Can Advance Their Purposes by Working Together. Wouldn't it be nice if we worked together? So this paper literally just released today. It has a bunch of thoughts about ways that we could work together. I'd encourage you to have a read of it. We talk about a spectrum of collaboration, the different types of collaboration that there might be, and then we break down what those would involve. Feel free to send it to your boards or other people you know to stimulate a discussion. I think too often we are getting out the number 8 wire to fix problems when our cousin across the road already has a solution. So we need to talk to each other more. So that's called collaborate. Like with all of our content, we would really love it if it's of value to you. The way you can say thank you is by sharing it, by posting on LinkedIn, by letting other people know about it. Yeah, that's how we get content out. So equally, if this webinar has been helpful, please consider sharing it with other people. We are going to put out a recording. I think we'll probably make it a Seeds podcast episode where there's about 500 episodes now of inspiring people and interviews and conversations with them. And just for those of you who joined late, Perryfield, we're really an impact-focused law firm. So we have about 100 people across 5 offices. We focus on property disputes, corporate commercial, and then have all of the subsets under that: employment, immigration, all of these things that you may need help with in the future. We have a lot of free content on our website. Feel free to check it out. There will be a follow-up email, and it will have links to the recording, and it will have links to the different documents that I've been mentioning. But finally, just want to say thank you for all the work that each of you do. We are aware that all of you are probably wearing multiple hats, and you're probably involved in charities, PTAs, sports groups, community groups, religious groups, all of those things. So we just want to say thank you for all that you do. And thanks again to Paul and Anna, and behind the scenes, thanks to Bridget and Jack for being stars and helping deal with IT issues as they come up. Yeah, we got through it. So thanks, everyone. Have a good rest of the day, and look forward to seeing you at a future webinar. Ka kite anō.
See you.